24 hours, 7 days a week. You can find your favorite program, Law and You, only on PinnacleTv.
Hello, welcome to today's episode of Law and You. Why did Atiku Abubakar lose his presidential election petition? We're going to be looking at five reasons why Atiku Abubakar lost his presidential election petition at the tribunal. And I've got with me right here my very good friend, my learned friend, my colleague, my buddy to discuss this topic, Barrister Innocent Ukpai. Don't go away.
24 hours, 7 days a week. You can find your favorite program, Law and You, only on PinnacleTv.
Welcome back. We're looking at five reasons why Atiku Abubakar lost his presidential election petition. 5 reasons. There are so many reasons. We want to look at 5. And I've got with me in the studios Barrister Innocent. Now, Innocent Ukpai is a barrister at law, a solicitor, advocate of the Supreme Court of Nigeria, a warrior in court. And we fought some battles and now we are friends in law. Okay. Innocent, welcome to the show.
Thank you very much. I'm happy to be here. Thank you.
Now, Atiku Abubakar went to court, the Presidential Election Tribunal, angling to become the president of Nigeria in place of President Muhammadu Buhari. He claimed that he won the election, and that Buhari lost the election, but was erroneously declared as winner by the Independent National Electoral Commission, INEC. Can you tell me why, in your opinion, do you think he lost the election?
Thank you very much. In my humble opinion, I think there are too many reasons why he lost. But I think all of them are all centered on evidence. Actually, in law, as far as the cause is concerned, it's all about evidence.
Evidence.
No matter how beautiful you think your case is, if you got no evidence to prove him, it goes to nothing. So essentially, in all ramifications, his case was bound to be dismissed based on either paucity of evidence or inadmissible evidence or weightless evidence.
Okay, so let's just break it down. First of all, by the judgment of the tribunal,
yes,
the judge took a long time. The judges, particularly Justice Lawal Garba, Justice of Court of Appeal, took a long time to say, he analyzed the evidence. He will say it's hearsay evidence. You analyze the evidence. You say it's hearsay evidence. You analyze the evidence. You say it's hearsay evidence. And at the end, he said all of this evidence, I couldn't believe it. So let's take number one issue. Atiku's overwhelming reliance on hearsay evidence. What is hearsay evidence, and how did that come to play in this Atiku's petition?
Thank you. Evidence ordinarily in law.
Yes.
Evidence is weighty if it's direct. In fact, evidence is ordinarily admissible and weighty when it comes from direct knowledge.
Direct knowledge
of the person testifying. In other words, if I'm going to give you an account of how this place looks like,
yes,
I should be saying, I looked at it,
yes,
I saw it on this day,
okay,
there was this white painting,
okay,
there was this, there was that.
Okay.
I'm not going to be saying, I was told by Mr. A that the studio is this, I was told by Mr. B that the studio is that, I was told by Mr. C that the studio is this. So it's indirect, it's hearsay. In other words, it's what I was told by another person.
So majority of Atiku's evidence was a repetition by witnesses of what they were told by other witnesses.
Yes, please, and
by
not what they witnessed,
and
not what they saw. Now the evidence that says if you must give evidence,
yes,
it must be direct. In other words, if it's something that's capable of being heard, must be by a person who say he heard it.
Okay.
If it's something that's capable of being seen,
yes,
must be someone who say I saw it.
Okay.
So it's not just somebody telling you, no, it seems it's like this or it's like that, or it's what you exactly witnessed, what you saw, what you read, not what someone told you about it. And that's why it's hearsay. And all over the world, hearsay evidence are inadmissible. And if even admitted at the point of judgment, they are bound to be expunged.
They are bound to be expunged.
From the government.
Now, Atiku was saying that the election was there was rigging, there was attribution of votes to President Buhari. In other areas where he won, there was deflation of his evidence, etc., etc. In other words, he was speaking to things that occurred either at polling units or at mainly polling units.
Exactly.
So, I mean, you are a lawyer. What do you think was the difficulty for him to have just gotten the people who saw these things? I mean, is it that his lawyer didn't know this?
I don't think so. I think it's probably lack of preparedness, as it may be.
Okay, lack of preparedness,
yes.
adequate preparedness.
Yes.
Okay.
I think in this regard,
yes.
our election petition laws are very clear on it.
Yes.
If you're going to say there was overvoting, you do one thing.
Yes.
You must call someone from that polling unit. Just overvoting is not a world issue. It's not a state issue.
It's
a polling unit issue.
Okay, overvoting.
Yes, there can only be an overvoting in a particular specific polling unit.
Now, overvoting, correct me if I'm wrong, means that, for example, there are 500 registered or accredited voters, not just registered now.
I follow.
500 accredited voters, people who are accredited to vote on a particular day.
I follow.
Instead of 500 people voting, 1,200 voted. That's basically what it is.
Exactly.
So you are comparing the people who are accredited to vote against the actual number that voted, and you come to the conclusion that, you see, look at those accredited, look at the number that voted. So there was overvoting. So that should be cancelled. Consequently, it is the evidence of somebody who was there, isn't it?
Correct. And particularly so too, because you can never vote unless you are accredited.
Okay, that's right.
That's so. Okay. Once you miss accreditation, it means you never voted.
Okay.
So overvoting is very simple. It's mathematical. It's scientific. It's capable of being shown exactly. It's not capable of being presumed or guessed or approximated.
Okay, so in the absence of calling specific people, I would have thought that Atiku's lawyers, with all due respect to them, I'm sure they would have known this fact. Even if they didn't have time to prepare, enough time to prepare, which we'll deal with as if there was time. How did they expect magic? I mean, on this point of relying on hearsay evidence, did they expect that the tribunal would have glossed over it and said, well, even though they don't have direct oral or evidence of people who witness these things, and let's just forgive them and let's just accept what they are saying? Do you think they were expecting that kind of emotional, sort of sympathy from the court?
Emotional sympathy, no, but probably, in fairness to them,
yes,
maybe they would have considered, or maybe felt that once they drop in some certain documents,
yes,
would have been enough to
okay.
Probably that was
okay. So we'll come to that. That should be a second point I want to look at in terms of the dumping. So the first one we have looked at now is over-reliance by Atiku Abubakar on hearsay evidence. That's number one reason for the abysmal failure of his petition. Second one I want us to look at is the failure to link his evidence with his grounds of the petition. And that's the point you just made. That they believe that if they can present every document and just give it to the tribunal across the bar, that the tribunal will then, in relying on one authority which their lead counsel, Levi Uzoku, SAN, cited, that once you give documents to a court, it then becomes the responsibility of the court to look at the document and to link it to your evidence. The judge can help you do that. I mean, why didn't the judges just help them out? Come on, talk to me, sir.
For a start, the point is the judge is not an interested party.
The judge is not an interested party.
So he does no work for anybody.
Okay.
He only assesses what you've presented, the way you've presented it. He can't even change it for you. In other words, if you are presented 1, 2, 3, 4, he cannot even change it to say, let it be 3, 4, 5, 6. The way you bring it in, the way you're going to consider it. And the only thing you now decide, has what you've presented prove your case? It's either a yes or a no. Okay, talking about documents.
Yes,
it's almost the practice, the procedure in most tribunals in Nigeria.
Yes.
Which is usually not always adopted by the regular course. Because of the time issue,
Yes.
most documents are tendered across the bar, not through a witness. It's an unusual procedure.
Okay, most documents are tendered across
Across
the
the
bar
bar.
by lawyers. So the lawyers just give it.
put it together,
Yes.
and it's dropped.
Okay,
in.
great.
But then the law have also developed in this regard.
Yes.
It has been held in several cases, countless.
Yes.
The fact that the parties agreed for document to be tendered across the bar does not mean that you wouldn't tie up your evidence. You must demonstrate evidence. Documents don't speak for themselves in this regard.
Okay.
You demonstrate it. How this document, and this other document all add up to show this. Why this other one? And you must do this through a witness.
You must do it through a witness.
Through a witness. You don't just drop it. If you drop it and you don't tie your case around that evidence, the court considers those documents having been done. And that's exactly what happened. You said there was overvoting. And by the way, it's not even an issue of time that was the problem. Atiku never complained that all over the federation there was overvoting in every part of the federation. No.
No, he called them focus states,
yes.
11 focus states.
So he put those states.
Yes.
He could have concentrated in showing overvoting in those states. So you were not looking at 36 states. You were looking at 11.
11, yes.
So he would have considered those. He said, yes, some places Kano, demonstrate it. Who was there? Who is the returning officer there? Who was the party agent in that unit?
Okay.
Who? Then you tender that document through that person, or if you have tendered it, in his evidence on oath, you demonstrate it through him. Yes, by this particular document, he shows that 10 persons were accredited, but only 500 voted.
Okay. But
I follow.
okay, you were saying he should have called party agents or polling agents from each unit.
Yes, sir.
That would have meant hundreds, if not thousands, of witnesses, because in every state you have these hundreds, so if you multiply them, you're running into probably 2,000-3,000.
Yeah.
So you need one person per unit, within the time, and the number of days that he had, about 6 or 9 days or thereabout, I don't know how many days he had now, to call his own evidence. Could he have achieved this?
He could have.
Or did he set for himself an impossible task on this point?
No, actually, on a different schedule, I've spoken about these issues.
Yes.
It's a tasking principle in Nigerian election matters.
Okay.
And I don't know how they wanted to fly.
Okay.
The principle as it is now,
Yes.
before we go into the criticism of it, whether it's good or not, is another thing.
Yes.
The principle thing now is this. If you must say there was overvoting,
Yes.
you call a registered voter from that polling unit to demonstrate there was overvoting. Anything short of this, as it is now in Nigerian election petition matters, it's unacceptable.
Okay. You
So
call a registered
voter
okay.
who was there,
Not just
anybody,
a person standing by.
As a matter of fact, there must be some active participation, because that is an active participation that you notice that was overvoting.
Okay, exactly. Okay.
Otherwise, because he was even passive, he wouldn't have noticed that the people overvoted, or
Yes.
there was such issues. So that's the principle of law here. So until and unless the Supreme Court consider this issue and reveal it, almost going to overvoting is almost like a moot point, as if that ground does not exist. In my candid opinion,
It's impossible to prove.
because if you take a state, for instance, Kano State, the 11, just one of the states, not the 11 states,
Yes.
just one of the states.
Yes.
How many polling units are there in one state?
In one local government.
In one local government. Then
in one ward.
How many days are you going to take to do your trial?
For example, where I come from in Orionwo, in a part of Edo State.
I follow.
In my ward, we have, I think, in my local government, we have 12 wards, 12 political wards. Each ward has a minimum of between 8 to 10 to 15 polling units.
I follow.
So if you are going to demonstrate, so you are looking at, let us say, an average of 10 units per ward, times 12.
That's 120.
120, so you have to call 120 witnesses to prove overvoting.
In one local government
in Edo State. Government in Edo State.
In Edo State.
That's one local government.
In Edo State.
Oh,
and then they call 62 witnesses. How are they going to do that? So it's not just about Mr. Atiku in this regard, with the greatest respect.
Yes.
I think there should be a point
where
the Judex.
Yes, the Judex. Who's that now? Many of our viewers may not know Judex.
Actually, the judges.
The judges.
Particularly the justices of the Supreme Court.
Yes.
May reconsider.
But is this their issue, or is an issue for legislators? That is the law as it is. The role of judges is to interpret the law.
I think it's a little bit of their issue, because it was in the interpretation of the Evidence Act
Yes.
that the Supreme Court arrived at that conclusion, that principle of law, that to show overvoting, they must be registered member from that particular polling unit.
You must bring the voters register.
Yeah, I'm not just because that's how you show he's a voter.
Yes.
And in fact, he even participated in that place. He's a voter in a particular unit. So it was an interpretation of this direct evidence and all that in the Evidence Act that the Supreme Court got to the conclusion that to prove overvoting, bring us a registered voter from that polling unit. Anything less than this is not acceptable to prove overvoting. It happened in Abga. In Abia State, when Abga was granted victory at the Court of Appeal.
Yes.
And a particular local government, some local government were just cast there was overvoting.
Yes.
It went all the way to the Supreme Court. And luckily too, Olanipeku was in the case, argued before the Supreme Court.
Olanipeku, senior advocate, was in the case too. Okay.
And he told the court very simple. That overvoting is not a local government based idea. No. It's overvoting as per polling units. He argued before the Supreme Court. Before he said it's a local overvoting, those polling must be identified.
Okay.
The votes, the accredited members shown, the actual people who pointed the vote shown, and then you say it's overvoting. Then you cancel that unit.
So not local government.
Not even local government. And the court the Supreme Court wholly accepted it and brought back the local government council, and that's how the current governor got into that seat. The court have already held otherwise. So this issue now went to the Supreme Court and said, no, there is no overvoting.
You got to love lawyers. You got to love lawyers, viewers.
So the case, the Supreme Court overturned that judgment. And that was it.
So all of this really turns on the artistry, turns on the mastery, turns on the ability, the efficacy of the legal teams on either side.
Exactly.
To be able to marshal their points one
and
way or the other.
Prepare against support. You should expect some blow from some corner. Because in fairness, the respondents merely waited for them to do whatever they wanted to do.
Okay.
If he said it was going to be overvoting.
Yeah, okay.
Good luck.
Prove it.
No, good luck. You said there's overvoting in 11 states.
Yes.
Good luck. Let's see how it goes in 60 days.
In 60 days.
In 60 days. That's all. That's why they even why there was already preparedness. We're going to cut this. We're going to be. They relaxed. Waiting for them. Okay. There's overvoting. Well, are you a registered member? No. Are you in this place? No. That's all for this witness. Bring another person.
Okay. All right. I apologize if I laugh. My laughter is, it's actuated by goodwill. Okay. Now, so we've looked at two. The first is reliance on, inordinate reliance on hearsay evidence, which was a fiasco. Second one is failure to link his evidence with his grounds of appeal, the principle of dumping. So he brought all these documents, just dumped them on the tribunal and said, you know what, you go and read it. So let's look at the server issue, number 3, which played a prominent role. Number 3 point, why Atiku Abubakar's election petition crash landed. The server fiasco. He told from the very beginning. He said there were 2 servers he flew, the theories of 2 servers that he flew. One, he said INEC had a server and he wanted access to that server. In fact, before he filed his petition, he filed a motion in court in the tribunal asking for permission to view the server. And he fought this one all the way to the Supreme Court and lost. Okay. Then the second one is he said there was some server called, server or website called factsdon'tlie.com, which was on some server, which was uploaded by an anonymous INEC official, and then which he now brought an expert from Kenya to come and analyze. And on these 2 points of the server issue, he failed. Why do you think that was so, sir?
It was bound to fail in the server issue, unfortunately.
It was bound to fail on the server issue.
And I'll explain what I mean.
Yes.
First of all, he files his petition. One of the grounds is that Mr. President was not lawfully declared.
Yes.
He should be the one to be declared because according to him,
yes.
He had the majority of lawful votes. By extension to his state. Yeah, because the vote he purportedly got, according to him again, is shown on INEC server, and he calculated it, stated it. Look at what exactly got. Look at what Mr. President got. So I should be the one declared
winner
because this is according to the INEC server.
So he had his computation of votes. I scored this. Buhari scored this. If you compare the two, I won. And then to get this is on INEC server.
Yes, and he said,
Yes.
so all these things, like you said,
Yes.
allegedly on INEC
Server, okay.
Then after filing your case, you apply to have access to the server, and I don't get it.
So
You
are you
said,
not supposed to have had? Was he not supposed to have had it?
so were you
before
speculative?
filing?
In fact, were you speculative when you say you got this vote and it's contained in the INEC server if you don't have it already? Are you fishing for evidence? Nobody fishes for evidence. You get evidence right there, or you don't have it. You don't
It's
file
either
a
you
case,
have the evidence,
or you don't have
or
it.
you don't have
You don't file a case, and then you start looking for evidence. Fishing. There's a principle against fishing of what? Evidence.
Fishing for evidence.
Yeah, fishing for evidence.
It's not allowed in law.
You can't do that. You can't bring it, because from day one, everybody should know your case.
Yes.
You don't file a case and then run around looking for something to prove your case. That's not how it's done.
Particularly within the context of election petition,
Exactly.
which you must file within 21 days, presidential election petition.
I follow. That's correct. Then,
Yes.
then there was a problem there.
Yes.
You file this case, you do this mathematics, state all the votes you allegedly got and all that. Then you ask the defendant, very carefully too.
Yes.
Join the issue on existence, not whether you got that vote, but that such server does not even exist. They were very careful in their defense. It was very categorical.
Does it exist?
They don't say that maybe it does. They say it does not exist.
So you can't ask INEC to produce something that does not
Now you
exist.
ask the court, please allow to have access to this. There's a joinder of issue as to whether or not INEC server exists, and why that is happening.
Yes.
Why that have not been decided. You cannot decide as, of course, a matter of fact.
Yes.
You can't at the interlocutory stage decide a substantive
Issue,
matter.
okay.
That's exactly how that issue was taken care of by the Supreme Court. The defense, the first respondent, particularly the first respondent, the INEC, has said we don't have any server.
Yes.
We never use any server.
Yes.
And you asking the court to mandate them to give it, to allow you to have access to a server, which is the substantive issue. The substantive issue here, part of the substantive issue that will tell at the judgment, is whether or not INEC has a server or not. You cannot now tell them before the judgment
Yes,
whether the
to
court has
produce it.
to produce a server. So it was a fruitless journey to the Supreme Court. The Supreme Court didn't say, oh yeah, you should have access, you shouldn't have it. He said, hey, parties have joined issue as to the existence or non-existence of this server. And why that is the case, you cannot decide a substantive issue at the interlocutory stage, because here you go back. So you can't if at the end of it you're able to establish that there's a server, then you can have a case. If you don't, you can't compel them to have access. And of course, in fairness to Mr. Atiku too,
Yes.
assuming he was able to establish that a server exists,
Yes.
the law provides for a way to take care of these issues, some of these issues.
Okay.
For instance, if you are giving them notice to produce
Yes.
the server, and they deny their existence,
Yes.
and they say they don't have it, and all
Yes.
that. And in the long run, at the judgment stage, the court holds that a server indeed exists.
Yes.
Very simple. The evidence has presumption of evidence, presumption against withholding of evidence.
Okay.
The court will say, yes, there is a server, they gave you notice to produce, he didn't produce it, we presume, as the evidence are allowed to presume, that the server he produced would have been against you.
So on the whole, and to simplify it for our viewers,
Yes, sir.
whose responsibility was it to prove the existence of the server?
He that has that must prove. Atiku said there's a server, he is bound to produce.
So how could he prove the existence of a server that he himself said was with INEC?
Particularly if he can purport to show or
Yes.
to contend,
Yes.
to present that he got this vote that is contained in the server.
Yes.
Then where did he get the vote from? How did you calculate the votes he said he got from the server?
So could it be that I don't know, can we speculate, because he had a good team of lawyers. Most of them were senior advocates, respected senior advocates of Nigeria. And in Nigeria, if you are made a senior advocate, it means that your expertise has been recognized in a way. You've been elevated to a rank.
Correct.
So all these senior advocates that he had on his side,
Yes, please.
did it not occur to them that, how are we going to prove this existence of this server if now that INEC had denied it? Why don't we just go and bring the server if we have it, anywhere we get it, whether we have, I don't know, anyhow, because evidence unlawfully obtained is admissible in Nigeria. provided it's relevant, isn't it?
I follow. But my take is this: they didn't have to bring the server to show that the server exists.
Okay.
That's actually
they didn't have, because the server could. They didn't have to bring it.
If like they purported, they brought some documents, some things flowing from the server.
Okay.
Which I think is what they should have. If they can say we got this number of votes and it's recorded there, they show, and they demonstrate where it's gotten from, how it was gotten, the time it was gotten,
who got it,
and the time
who downloaded it,
and how it was downloaded, the time they got it.
Yes.
It will show that it exists. I mean, if you say Google does not exist,
yes.
I mean, you just print out stuff from Google.
Print out from the website.
Show it, and show when. How?
Okay, that brings us to the second point. They went to the extent of printing out. Okay, they couldn't do the server thing, but at least they were able to do factsdon'tlie.com. They printed out things from that website. That also failed.
Okay, probably
that also failed. Why?
Probably this takes us to a Kenyan guy.
Yes, the Kenyan guy.
Yes, as
the star witness for Kenya.
Exactly. I mean, the facts were very simple.
Yes.
They said there's a server, and you were using during election. You travel to Kenya, bring someone who was never in Nigeria, who knows nothing about Nigerian election procedures, who knows nothing about the documents even used in the election.
Yes.
The forms used in the election.
They asked him
you don't even understand anything.
And he didn't even know what.
And then who was far away in Kenya within this period? He was never here when this happened. I just come on and say, yes, there's a server. And they ask you a question, you use it, say yes. Okay, where is this form? You don't know it. What do you use for? You don't know it. And you're supposed to be an expert in showing servers and election matters.
Okay, I'm going to stop you there. We will continue when we come back. We'll take a short break, get a brief message. Please don't go away. And don't forget to subscribe to YouTube channel of PinnacleTv online so that you can keep getting updates, any video that we post. And then, are you enjoying this? Let us know in the comment section. Do you hate this? Let me know. Let me know if you hate Law and You, or if you love it, let me know. Phone number is there. Talk to the producer, and then we'll get right back to you. Don't go away.
24 hours, 7 days a week.
For more exciting, educative, and entertaining programs such as Law and You, Talk Politics, Entertainment Gist, Relationship Talk, Top 5 Gems, and other programs, keep watching Pinnacle TV. You can watch, like, and subscribe to our YouTube channel at PinnacleTv Online. You can also visit our website at www.pinnacletv.com. Follow us on Facebook at PinnacleTv Online, or call us on 081-546-99989. Pinnacle TV, top quality broadcasting.
Welcome back. Barrister Innocent was talking. You were talking about the Kenyan guy. You know, the guy who came from Kenya, couldn't answer, simple questions. Now, what intrigued me, and I keep asking this, is when he was asked, which institution, organization, educational institution, or school, or company certified you, in computing or
as an expert?
As an expert, basically. He said none. So, is it that this Atiku's lawyer didn't know this? I mean, this is an elementary question to ask. Every lawyer would first ask. You are coming to testify about something as an expert. Excuse me, sir. Where did you study? And it ought to even be stated, in the witness statement on oath. First, second, third paragraphs. I attended social school. I have been working in this field for 20 years or 10 years or 5 years. I've acquired masters or PhD, or, I've built this website, built that website. You know what I mean? Something to validate your claim to be an expert. So how come they failed on this, so obvious point?
Okay, if I may take it from a different angle.
Yes.
In fairness to the Atiku's team, as a matter of fact.
Yes.
They needed to actually have the Kenyan guy.
Yes.
Ordinary wouldn't need to have been certified.
Okay.
Educationally.
Yeah. Okay.
To be an expert,
okay,
it's about skill.
It's about skill.
It's about skill.
Okay.
You are an expert in an issue.
Okay.
How you been so highly specialized in this particular skill that you are
practical experience.
Exactly.
That over a long period of time, and that gives you the expertise to call yourself
I must
an
show
expert.
A, B, C, D you've done before.
Yes.
You don't just wake up and say I'm an expert.
But he failed on it.
And you showed nothing because you think you can run a computer, you can get to a server, you think yourself you're an expert. Then everybody in Nigeria is an expert.
Okay.
Because how many millions of naira everybody goes on net. So you don't know anything about this.
We don't want to make this interview too big on this one. So we've looked at these three. First one, reliance on hearsay evidence. Atiku failed on that. Failure to link his evidence with the grounds of his petition, that is, it dumped. Then he failed also on the several, theories or principles or grounds.
Sure.
So we have more to go on this, but this is all we can take. The producers are telling us to cut this short, so we'll do part 2 of this, and be sure to come back and look for part 2 of this, and keep subscribing to our YouTube channel. And please, you need to subscribe. You need to send us your comment. And please press the like button so that people know that you like this program, Law and You. That's how it's been today, Barrister Innocent. Bye. Thank you so much for coming on the show.
It's my pleasure.
Keep a date with us.
24 hours, 7 days a week. You can find your favorite program, Law and You, only on PinnacleTv.